introduce you and let you do your own bio, if that's all right. Anyway, good evening, everyone. Glad to see you here tonight. This is our fourth session on the Resurrection Seminar Series, and I'm glad you're here tonight. Before we start, let's bow our heads in prayer to get started. Dear Lord, we ask your blessings this fourth meeting in the Hope of the Resurrection Seminar Series. Whether you're at a stage of life starting your career in families or transitioning to the sunset of life, we pray planning for the future will bring comfort to us and our families. We ask you, Lord, to be with our speaker tonight, Tom Hay. He will be presenting many planning items we should take care of during our lifetime on earth. To make this smooth transition for all, we ask all of you in your name, amen. So a couple things before I introduce Tom. This is the fourth one of our meetings. Some of you people had a chance to go to planning funeral services. And if you need more information on that, it's on the website. And Bonnie knows that well if you have a hard time getting on there. And there's also a copy of the planners, and you can actually contact them if you want to. Also, we had the one on retirements, assets, liabilities, and all that. We had Evan Tidball from Edward Jones Financial. He's a local guy here in town, very helpful to many people, so he's a source we use for our second one. And the third one was the 5 Wishes of Healthcare Agent and Medical Treatment Wants and Don'ts. We had Wendy Van Klinken from Chaplaincy Healthcare, and we also had Allison Bestebuer, who's an RM with the Prosser School District, and I understand that was a good series too. So that's all on our website, prosserpress.org. If you have a hard time, you can go to events. If it's not under events, it's under other, I think, or something. So that's on there. And Tom will be able to answer question and answers afterwards. I've asked him to repeat the question because we only have one microphone tonight. So with no further ado, Tom, good evening.
And thank you very much. I think I'd rather sit for an hour than stand for an hour. My name is Tom High. I'm with the law firm of Walker High in Richland. I graduated from Cornell Law School in Ithaca, New York in 1966. And I was from the state of Washington at that time. I came after graduation and clerked for the Supreme Court in Olympia for 1 year. And then, by the grace of God, I moved to Richland, Washington after I finished my year of clerkship and fell in love with the Tri-Cities and the whole eastern Washington, having grown up in the wetlands of Olympia. And I hung around here for about 4 years, and then was offered a job with the Civil Aeronautics Board in January of 1971, and I ended up there for almost 5 years and ended up as general counsel of the Civil Aeronautics Board before I returned to the state of Washington in 1975 and went back into law practice again in the Tri-Cities in Richland in 1976. And I made a cursillo in 1976 in March, and my whole life changed at that weekend, and year and a half, September of 1977, I became a senior partner of the firm in March, and in April announced that I was going to leave law, and I went to Belgium and studied theology for 3 years, thinking that I was going to become a priest, but God had other plans for me, and I'm flashing back to a moment in January of 1977 when a lawyer from Eisenhower Carlson in Tacoma was visiting in the Tri-Cities, and we had taken the bar together in 1966. And I said, Dick, I want to talk to you about something I've never spoken about with anybody. I'm thinking about leaving law to become a priest. And the first words out of his mouth were, you'll do more good for people as a lawyer than you'll ever do for them as a priest. And having spent 3 years in Belgium and realizing that that's not where the Lord wanted me, I came back and went into private practice again and have been in private practice basically ever since in the Tri-Cities in Richland. And the last 10 years of my life, I flash back to that moment when Dick Turner said to me, you'll do more good for people as a lawyer than you will ever do as a priest. And I saw that in action, especially the last 15 years of my life. Because a lot of the work that I do is going after people who rip off parents or elderly people. And that sets me off on a crusade that I just can't let go of. So I want to talk to you tonight about estate planning. Before I start, I'm going to tell you a story. This gentleman, he and his wife were in their late 70s, early 80s, no children, and she died in February, many years ago. And he had two half-brothers who were in their late 80s, early 90s, who were in nursing homes. They had no children. And the wills that he and his wife had drawn left everything to one another. It was several $1 million. So I told him, I said, you need to do something about changing your will, because right now it's all going to your two brothers who are half-brothers who are in this nursing facilities. And he would come in periodically, and I would run into him in different places. When are you going to come in and get your new will signed? Well, I'm working on it. And I ran into him the first part of January the following year, and I said, when are you going to come in and get this, new will drawn up? He said, well, I'm working on it. And 3 weeks later, I get a call. He had a heart attack and died. I went out to his house, and when I went into his kitchen, he had a big round kitchen table, and on it were all these papers. He was writing down money he was going to give to nieces and nephews and other people. And he had already written in over $500,000 before he died. So I wrote back to the brothers back in the East Coast and asked, and I pointed out what had happened. And here's a list that he had already made. I sent him copies of it in his own handwriting. If you would agree, I would be willing to, lay this out so that this money goes to these people first and then the rest goes to you. And they said that was great. But the moral of that story is you never know how long you're going to live or what's going to happen in your life. So if you don't have basic estate documents right now, you should be thinking about this. And the basic estate documents are a durable general power of attorney for finances and health care. These give the authority to some other person to act on your behalf for finances or for medical. Although most of the ones that I do, the person who is in charge, who's given authority over finances is also given authority over medical, but it doesn't have to be that way. The other thing about a durable power of attorney, it can become effective immediately when it is signed, or it can be what we call a springing power of attorney. And that's a power of attorney that only becomes effective when you are no longer able to manage your own affairs. And for people my age, I'm in my 80s, I recommend that if you're in your 70s, make the power of attorney effective immediately, for the simple reason, if it's only effective when you have a written note from a doctor that you are disabled, that can be very, very difficult to get. Doctors don't like to write notes saying this person is incapacitated and no longer able to handle his or her affairs. And powers of attorney, by the way, they don't take away your power to do anything. You still have the power to do everything with regard to making decisions, etc., but you give that authority to somebody else as well. And the reason for that is because what happens if you have a stroke? Who's going to, step in? Who's going to have the authority to make decisions for you? And who do you want to make the decisions? What I tell people is, make sure that somebody you absolutely trust, that you don't have any qualms about whatsoever. And name an alternate person. Most of the times with spouses, spouse names the husband, husband names the wife. But then what happens if both are not able to act? Then you want to name somebody else. And when you're naming somebody else, there are various ways of doing it. One is you have a list. You start off with the first person, second, third, or fourth. Or what I tell people is, if you really are, good with any of the children, instead of making this one first, second, third, put down or. Then you can list John, Mary, George, or Henry. That way, any one of them can act on your behalf. And as long as we're talking about powers of attorney, because the power of attorney ends, by the way, when you pass away. It can only be used while you're living. And the other thing is, what I find with a lot of people, when they get older, and especially if they're a widow or widower, they want one of the kids on their bank accounts. And the problem with this is this: 90-some% of these accounts are set up by the people at the bank with the mother's name and the daughter's name as joint tenants with right of survivorship. What that means is that on the death of the mother, all that money by law goes to that one daughter. And I can tell you situations where the mother had the son on all of her bank accounts as a farming operation. Everything was in the name of the mother and the son as joint with right of survivorship. And when mom died, the son told the rest of the family, "That's all my money." So what you do is have the person on the account, especially if it's the power of attorney, have them on the account as a tenant in common, which means that on the death of the mother or the father, the money doesn't go to the other person on the account, it goes into the estate. So that's something to be aware of. And then the other problem is where you put in a lot of bequests and stuff like that in your will, but then you put the accounts as joint tenants with a bunch of people, and the money never gets into the estate to fund the trusts or whatever it is that or specific bequests that you're trying to deal with. So the powers of attorney are good while you're alive. The documents that deal with what happens when you move on to the next life, that's what we call a will, or in the case of married couples, a community property agreement. Most of the work that we do is with estates that are under $2.2 million. If they're over $2.2 million, you have to be concerned about what happens when the first spouse dies. Everything goes to the other spouse. There is no tax when it goes to the spouse, the surviving spouse. But if you got a $4 million estate and husband leaves $2 million to his wife, when she passes away, she's got $4 million estate. And the state of Washington starts taxing estates at $2,193,000. And it starts off at like 14% and goes up very quickly to like 18 and 19%. So what we do in those circumstances is generally we set up a disclaimer trust in the will and not use a community property agreement. And that's so that after the spouse dies, we can determine whether or not it's better to disclaim the property. If it goes into a disclaimer trust, the surviving spouse is the trustee of the money. Surviving spouse gets all of the income from it, but on the surviving spouse's death, it does not go into his or her estate. It passes tax-free on to the children or whoever the beneficiaries are. So those are things that you could do. And with regard to the other thing with regard to wills, you can name a guardian for any of your minor children. But also I recommend that you take into account the children or the people you're giving the money to. Because if you have a special needs child who's getting benefits from the state or the federal government, you do not want them to lose that. And so anything you're going to give to that child who has special needs, you set up a special needs trust in the will for that child. And by the way, this also applies to, you got a child with a drug problem. It's not a wise move to give somebody who's, got drug problems lots of money because, it disappears very quickly. So what you can do is set up a discretionary trust for that person and give somebody who knows this person the authority to dole out money as he or she seems, is appropriate. The other thing that you have to think about in terms of estate planning is directives to physicians. And this is a document that basically, if you have been diagnosed in writing that you have a terminal illness, meaning you're going to die likely within the next 6 months to a year, maybe 2 years, if you can communicate with the doctors and they want to put a feeding tube in your stomach, you can say no. The purpose of this document, the directive to physicians, is to let your family know what would you decide if you were able to make this decision. Because you may not be able to make the decision because now you're in a coma or you've had a stroke and you can't communicate with anyone. So they want to know, the family wants to know, what would mom or dad want us to do? And I can tell you, I've ended up as power of attorney for some close friends who had children. And why don't you have your son be the power of attorney? Because he'd pull the plug on me quickly. And I say, I understand. So yeah, these are I think of the situation, this was like about 25 years ago, there was a woman who was in her 80s at the Kennewick Life Care Center. And I was power of attorney for her. But she was not eating enough to what they say called thrive. And she was in the Kennewick, General Hospital. And I went in to see her, and was talking to her, and the doctor called me over, and he says, "Here, I need you to sign this document." And I said, "What is it?" "Well, we need to put a feeding tube in her stomach." And I said, "I don't think she wants a feeding tube." So I went in and talked to her, and I said, yeah, because she had mentioned before she didn't want any feeding tubes or anything like that. So I went in and talked to her, and I went back and I said to the doctor, "I won't sign it." He said, "You have to sign it because it's negligence on your part if you don't." And I said, "She's mentally competent. She knows what she's doing. She doesn't want a feeding tube, and I won't use the authority I have to override that. Because to me, that's a personal choice that people make, and you have to honor it." So she didn't get the feeding tube, and she lived another 6 months or so before she finally passed away. But if you can communicate with people, you don't need the directive to physicians. The problem is what happens when you can't communicate. And then the family has to get together and make that decision. And generally, the one who has the authority is the person who has the medical power of attorney. They're the one who's going to have the final say on something like that. But in the end, and I've learned this over the last few months because I've been dealing a lot with hospice patients, I don't talk about death anymore. What I talk about is moving on to the next life, because that's what it is. And I remember when I was sitting with this couple last month, and I said that to the gentleman, that when you move on to the next life, and after I finished, he said, "Thank you for saying that." Because that's what it is. I mean, that's the reality of it. I mentioned the community property agreement. I'm going to mention it again because we get a lot of people come in who don't have wills and don't have a community property agreement, and they tell me, "Well, this is a community property state. You don't need a community property agreement because everything goes to the wife." And I said, "Yeah, that's true. The problem is that you can only bypass probate if you have that piece of paper. It's a 2-page document." I said, "That's it. And if you don't have it, then you have to open a probate to clear title to the real estate. Whereas if you had this document, we would file with the auditor's office, and then a couple of weeks later, we're going to file an affidavit saying, when so-and-so passed away on such and such a date, he and his wife owned this piece of property, and they had a community property agreement that was recorded on such and such a date under auditor's file number such and such, and you file that affidavit so that the title companies then will have that document in their files, so when the surviving spouse sells the property, or the estate does, they can see that the chain of title is there because they had a community property agreement. So that's basically, when you're talking about estate planning, that's basically what you're looking at. And you've heard a lot probably about revocable trusts. And revocable trusts nobody used a trust unless you really had a reason for setting one up. But California has a law that requires the estate to pay the attorney who handles the probate a percentage of the estate. In the 1960s, in the state of Washington, lawyers could charge a percentage of the estate, and the Supreme Court, rightly in the 60s, eliminated that. And because, so down in California, what happened was a bunch of lawyers thought, I know how we can make a hell of a lot of money, and that is we will draw revocable powers of attorney. put all the property into a revocable trust. Put all the property into the trust. On the death, we say the trust property goes to so-and-so, so-and-so, and so-and-so. And you don't have to have a probate. So lawyers down in California were charging these gargantuan fees to set up revocable trusts. And then this has got to be 30-some years ago, I remember getting a flyer from a lawyer in Southern California who was going to do a seminar up here in the state of Washington on loving trust, not living trust, loving trust. And he copyrighted that term. And if you attend this one-day workshop, he will give you the right to use the term loving trust and give you all the forms, everything you will ever need to make these trusts. And if you sign up for Benton County, he will only let one person from the county sign up. Same thing. The cost of this one-day seminar, $25,000. And we had one of the local lawyers attend it, and he ended up spending the rest of his career, writing trusts for people and stuff like that. So you really don't need a trust if you have multiple properties in different states. It makes sense to have a trust where you put all the properties into the trust so that you don't have to have multiple probates all over the United States. I remember as a very young lawyer in the 1960s handling a probate for a young woman who died, and she owned a piece of undeveloped property down in Florida. And the property was worth around $6,000. It cost us $2,000 to probate the estate down in Florida back in the 60s. So, yeah, there's a lot of things that go on in this world, let me tell you. What else was I thinking of that I was going to talk to you about? That's basically looking at estate planning, overall. The other thing I want to mention to you is Medicaid. Medicaid is a system for people to get benefits who don't have any money. And in order to qualify for Medicaid, you have to have less than $2,000 in basically liquid assets. You can own your own home, provided that you intend to go back to the home, even if there's no possibility you'll ever go back to the home. As long as you intend to go back there, the home is exempt. The family can have a car. Jewelry is not counted. Household furniture is not accounted. But all other assets are accounted. And so with a married couple, the married couple is allowed to have the husband. Let's assume the husband is the one who's going on to Medicaid. He cannot have more than $2,000 in his name. The spouse can have $57,000 in her name, and it can go up higher, but that's basically, if you look at the area of about $60,000, that's where you have to be to qualify for Medicaid, for long-term care, and then there are other requirements as well, besides the financial requirements. Medicare, of course, is the federal system for, for seniors, and there are other people who fall into that category. But basically, the Medicaid thing comes up a lot. And the other thing with Medicaid that's important to remember is you cannot gift away your assets to your kids in order to qualify for Medicaid. And there's a 5-year look-back period. And if you give away or sell for less than fair market value property in order to qualify for Medicaid, when they come to apply for Medicaid for you, you're going to be turned down. And the people you gave the money to, DSHS can go after them for up to 150% of the value of what you were given. So when people get into their 70s and they start having medical problems, and they come in to see me and talk about wanting to give away their house or sell their house at some, ridiculous price to one of their kids, I said, you don't know if you're going to make it 5 years. And if you don't make it 5 years, you just created hell for your kids. Because it's who's going to pay for your care then if Medicaid doesn't do it? So those are some thoughts on estate planning. The most important thing is, if you don't have any of those documents, if you don't have a durable power of attorney for finances and health care, get one. And the same thing applies to doing a will. Because if you don't have a will, then the law of intestate succession goes in, and it basically goes, it's bloodlines is where it goes. And spouses, and But those are things that you want to get taken care of while you can. Any questions? Right. You don't need to. When my mother died, the will was like 25 years old or more, and I was named as the guardian for my younger sister. And the will was drawn back in the 1960s, and so there's no need to do it. It's just if you feel like you need to change it, if there's some changes you want to make. The other thing is when you're doing wills, you don't want to have a lot of money going to minors, and that's why we recommend an educational trust for children who are under the ages of 25 or something like that, because if you give a young person a lot of money, you know where it goes. I had a client, this is over 30 years ago. She was in a very serious accident when she was 12 years old. And she ended up with a cash settlement of over $300,000, which she got when she turned 18. And I lined her up with a financial advisor in Richland. And one day he called me and he says, your client, she's down in LA. She can pass anything but an ATM machine. She was taking out $400, $500, $600, $700 a day. And she died of needle poisoning at the age of 21 and had run through all but $60,000 of the money. So this is something you want to be aware of with regard to giving money to, young people. They don't have the sense of what, A lot of times I've done a number of wills where there's a big, substantial amount of money involved. And what we'll do is you get money while you are pursuing a higher education. After you turn 18, you're not going down to Southern California and hang around on the beach and get checks. If you don't go on for a higher education, you get nothing out of the trust until you get to a certain age. And by the way, that's very effective. And one of the things that's in there is the trustee only gives you money if you're serious about pursuing your higher education. And the best example I had was this guy is up at Central getting C's and D's. It's a letter. Unless you have a B average next quarter, no more money. Next quarter, all A's and 1 B. Never had a problem in school, going forward in the future. So yeah, you got to be, be very savvy about these sorts of things. But a lot of times what will happen is they'll say, okay, you get, and when you turn 25 years of age, you get 1/3 of what the principal of the trust is. When you get to be 30, you get half of what's left in the trust. And when you get to be 35, you get the rest of it. And generally, you find the early money gets spent on things like new cars. Oh, the gal with the needle problem, she called me up. She wanted to go over to Lescabar, and because she found this red pickup truck. She didn't even have a driver's license, but she had to have that red pickup truck, and the thing was way overpriced. I mean, they had a fish on her, it was unbelievable. And she bought it. I never found out how she got it titled or anything because she didn't even have a license that she could get titled with it. So, yeah, but you meet a lot of very interesting people practicing law, let me tell you. Yes? Yes. Yeah, oh yeah, it doesn't make any difference. The thing that you have to be careful of is to keep the account of the person on Medicaid below $2,000. That's what's important. And yeah. And then there is something for people who are super rich. There are Medicaid annuities that you can buy. But that's a whole different ballgame. Yes? Well, that's a question, of course, of how you line up what's going to happen. For example, if you leave the house to somebody and the house has a mortgage on it, or if you leave any real estate to anybody and has a mortgage on it, the person who inherits that takes that subject to the mortgage. The estate doesn't pay that off. Even as I've got a situation where we've got a multi-million-dollar estate, and when the mother dies, the daughter is going to inherit a house, but she's going to inherit that house subject to the deed of trust, even though there's cash in the estate to buy it, because there's no provision that that's what's going to happen, because the law says unless it provides that, the estate will pay it off, you take the real estate subject to the indebtedness. So one of the ways of dealing with that, of course, is through insurance, if you're eligible for insurance. And that's why younger couples, I tell them, go out and get yourself, a $500,000 or $1 million term life policy. Because if something happens to either one of you, you're not going to be able to make it. The surviving spouse isn't going to be able to make it on the kind of money that he or she's going to be able to make. And that's going to cost a hell of a lot of money, to take care of these kids and raise these kids. So, yeah, but that's a concern of people, that they've got this money, but is it all? It's not all in the right place that it needs to be. And you find there's a lot of people who don't have a lot of money. And a lot of people have a lot of credit card debt. Amazing amount of credit card debt. if there is a person dies, if there's real estate involved and not a community property agreement, you're going to have a probate of the estate in order to pass title to whoever is entitled to the real estate. If the estate doesn't have real estate and there's less than $100,000 in estate assets that are going to be part of the estate, you can use a small estate affidavit. And that you have to wait 40 days past the date of death, and then you do a small estate affidavit, and you fill it all in and say, you know, on such and such a date, Joe died. He had a car. He had these bank accounts. He had these checks. And Brother John is the one who signs this declaration saying, I'm entitled to this money in order to, you know, for all the people who have equal share in the money, authorize him to then, you know, go collect the money and get it distributed out among everybody. So that's another way to avoid probate, but that's only involves personal property items. If there's real estate involved, you're either going to have a community property agreement or you're going to have a probate of the estate.
I have one more question on Medicaid.
Yes.
If you give somebody X amount and you don't live 5 years, and they don't live 5 years, they live within that 5-year window, do both parties have to pay the penalty or just the one that?
No, it's no. If you've given away money, when you apply for, somebody's going to apply for Medicaid, and they're going to answer that question yes, and then the question is going to be, okay, how much did you get? And then they're going to say, okay, you got an extra $100,000 that you have to bleed down at a monthly reduction until all that excess has been taken care of. In the meantime, somebody's got to be taking care of, you know, the person on Medicaid who's paying the bills. But the state can go after the person who got the money if they hold that it was a gift to qualify for Medicaid. That's really the secret of the whole thing. It's a gift to qualify for Medicaid. And so it's going to be, you're ineligible for a certain period of time, and it's so much a month that gets reduced by.
Only the recipient of the money, right?
Right, only the recipient of the money is the one they'll go after. Right now, I think it's $16,000, but there's another option that you have. For example, you want to gift away a house or a piece of real estate that's worth $300,000 or $400,000. What you can do is you make the gift of the property, and then the following year you file a federal gift tax return, and you claim that you gave, let's say, $366,000. $16,000 of that you can give without paying the gift tax. But in lieu of paying the gift tax, what you do is you check on the form that you want to reduce your federal tax exemption for federal estate tax concerns. So right now, the estate tax exemption for the federal government is a little over $11 million. Well, very few people have estates over $11 million that they're giving money away. And, but if you gave away, if you fill in the gift tax return, you don't have to pay the gift tax. And when you pass away, unless your estate is greater than whatever the federal exemption is at the time you die, then you never pay any gift taxes at all. The thing about gifting property is, remember, what you gift carries the tax basis of the person who is the donor. And the classic case for me was as a very young lawyer in 1967, 68. We had this probate come in. This woman had quit claim her home in Richland that she got from the federal government for $8,000 some dollars. And she quit claimed that to her kids so that she wouldn't have to pay $1,000 probate fee. Well, when they sold the property had a capital gain on it of around $80,000 or $90,000. And so they had to pay capital gains taxes instead of the probate fee. And that's why we always tell people, before you start gifting anything away, come and check with us to make sure you don't get yourself into a situation that you don't want to be in. Yes? The question is really, if you don't have any estate planning documents, what is the best way to proceed? And I can tell you the best way to proceed is not to go online. It's like some of these talk show hosts, like, you did all of this without a lawyer? Why are you doing these things? And I'll tell you, the cost of doing estate planning varies widely from law firm to law firm. I've been amazed at some of the fees that have been charged by other law firms, just like, But when you look at it the way we sort of look at it at the office, with a normal situation of a normal average couple, what you end up with is 2 wills, 2 durable powers of attorney for finances and health care, 2 directives to physicians, and a community property agreement. And that runs around $1,100, $1,200 for a couple. For a single person, it's like $800 or $900 around in there for that sort of stuff. But I would never recommend going online or doing anything, because if you don't understand it, that's why you go to a lawyer. But it doesn't hurt to call around and find out what it would cost to get these things done. And I can tell you that, for example, with our law firm, 90% of the work we get is referrals. People who, have been, come to the firm are referred by somebody who's been with the firm. And there are a lot of lawyers. I mean, there are several hundred lawyers here in the Tri-Cities and Prosser area. So, but I would do is I would call around and check and, see what you're comfortable with. Right. Yeah, she's talking about a case where the gentleman went into the nursing home, and the wife ended up with the property in her name, but then she died before the guy in the nursing home did, and because of that, it all went back to him. You reminded me of a case that I had many, many, many years ago. The wife went into the nursing home, and, husband went into the nursing home really totally out of it, and so we transferred all the property to the wife, and then did a new will for the wife and left everything to the kids. The wife died. The house was sold. 6 months later, Daddy comes back to his senses again. I want to go home. Fred, you don't have a home anymore. The home was sold. But I've done this a lot with people with Alzheimer's, where we will transfer all of the property to the well spouse. And because that's an exempt transfer. And when the well spouse dies, everything goes to the kids. And if you do that, you can save the family a lot of money. Roughly, Medicaid pays about 60% of what private pay is. And and in these situations where the person is on Medicaid, I've had it where the woman died and her house sold for $90-some thousand, but her Medicaid bill was $190-some thousand. That's just the way it goes, plays out. Yeah, a lot of these things you got to make sure that you do everything. I've had situations where people, just sign these revocable trusts and everything else, and then they never fund them. And then they die, and I say, well, but you never funded, you never transferred anything into the trust. Well, that's why when we do trusts for people, part of the job isn't just to prepare the form, it's to actually fund the trust. Yes?
So how does it work when you have parents that each have separate wills?
Right.
And a trust. So let's say that I pass away before my spouse does. And then when she passes, which will is the one that is used to distribute the assets?
The trust is the distributing entity. When we do revocable trusts, what we do is all the payout on death provisions are in the trust. The only thing that's in the will is a pour-over clause. On my death, anything that's in my estate gets put into the trust. And the reason we do that is because people forget that they've got some of these things. And so what you do is the trust is the entity that disposes of everything. And the will just does nothing but pour over any assets that are not in the trust into the trust. So it's all controlled by the trust. That's how that's done. No, the will only deals with what's in the estate. But if all the assets have been transferred into the trust, there's nothing for the estate to do. That's the whole thing in a nutshell. If there's nothing for the estate to do.
So I think what he's asking is then how does everything in the trust go to who it's supposed to go to?
Because you've named a trustee. Generally, it's a husband and a wife, kind of a trust. But on the second death, you name a successor trustee who's now going to be responsible for distributing all the assets in accordance with the provision of the trust. Normally, the will is the one that has the dispositive language in it, But when you are using a trust document to control your assets, then the will is nothing more than a channel to funnel any assets that you forgot to put into the trust, because the trust is supposed to deal with everything.
So the husband and wife together then will decide what they want, how they want the trust.
Exactly. Well, the trust document itself is going to say what happens when both of them die.
What happens when parents disagree on the distribution of assets?
Then they have to agree on the distribution of assets, because otherwise you don't have an agreement. You have to have an agreement. If you're going to have a trust document, you have to agree what the language is going to be. And then the way you can generally do that is to say, okay, I'll agree that these assets go to this person, but you have to agree that these assets go to this other person. But then, oh, you do, yeah, exactly. And the other thing you got to remember is, when the first one dies, the question is, does the trust become irrevocable as to the dispositive language on the death of the first grantor of the trust? Because if you don't make it irrevocable, then the surviving spouse gets a new boyfriend or girlfriend and decides that they want to leave a chunk of this money to this outsider. So those are the sorts of things. That's by the way, that's why you go to lawyers. Because lawyers think about all these crazy things that people do. Why? Because we've seen it. We've actually seen this sort of thing happening. Yeah. Oh, yeah. One of the things in cash, it's an amazing thing. Cash disappears like you can't believe. The dad and mom always had $10,000 cash in their safe. The daughter shows up after the death of the father, and all of a sudden the $10,000 that was in the safe is gone. Where did it go? I don't know. No, this is what happens. When I was studying theology in Belgium, one of the wisest things was ever uttered by one of the priests over there was, just remember one thing: 90% of virtue is lack of opportunity. Yeah, and that is very, very true. Yeah. Yeah, money, and I'll tell you something, money does crazy things to people. Families you would think would never get into battles, they get into the most unbelievable battles over money. And it's not always the people with a lot of money. Some of them don't have a heck of a lot of money, but they fight tooth and nail over it. Anything else? Oh, you get people who are just absolutely unbelievably pushy and rude about, stepchildren wanting to step in and say, I want this and I want that. And say, wait a second, you don't inherit anything. Yeah.
Very helpful.